Well, hello again, everyone, and welcome to this panel on understanding your separated rights. My name is Albert Munoz. I'm a union organizer on staff at the Guild. On behalf of member organizing, our member organizing department, I'd like to welcome you to the panel, and thank you for being here to learn more about reacquiring the rights of unproduced original theatrical scripts. If you are interested in TV streaming separated rights, great. We hope to have a panel organized soon about TV, but tonight's event is about theatrical scripts. Tonight's event is also designed to empower you with information about the MBA, or the Minimum Basic Agreement. We're going to be talking a lot about that today with our panelists. And as you might know, our current agreement is set to expire on May 1st of next year. As we prepare for negotiations with the companies, I encourage you to stay connected to the Guild through our Captains program. It's how writers stay connected to other writers during negotiations. So if you're not already hearing from a captain, please reach out to us and I'll hook you up with a captain so you could stay connected during the upcoming negotiations. So we have a lot of useful information to cover and we want to make sure we have time to hear from you. So we're going to dive right in. We will have a question and answer section at the end. Please be ready to turn on your camera and your microphone, and you will be asked by Zoom to become a panelist. Just click yes, and then you'll be on stage with us and you'll be able to ask your questions. And so now it's my pleasure to introduce you to our panelists, WGA members Allison Schroeder and Eric Warren Singer, and our co-moderator is Senior Counsel Brad Schleder. Welcome, everyone.
Thank you. Excited to be here.
Yep.
So, Brad, take it away, man.
Well, thank you everybody for joining us this evening. As you know, you're here. This is a theatrical separated rights discussion focusing specifically on reacquisition. You may have heard something recently about some favorable arbitration award that the Guild received with respect to this. So that's part of the reason why we're here and talking about it. So question for the both of you first, when we get into this, when you hear the term separated rights, what goes through your head? What's your first impression when you hear it?
That I want it.
Yeah.
Yeah. I mean, good.
Allison.
I was just saying, it was funny because I was on a panel with Brad, like a year ago, and he mentioned separated rights. And I literally called him after the panel and went, wait a minute, are you telling me I can get back this script from Paramount? And he was like, yeah, are you serious? And we triggered it within like a few weeks. And so the first time I heard it was, what are those? And then now it's like, how can I always get them?
And I think it's important to understand that separated rights covers a broad spectrum of rights that we hold or potentially could hold. Reacquisition is like, correct me if I'm wrong, Brad, but if it's just one component of this bigger umbrella. And that big umbrella, to me, really, when I think about it, is sort of the future of the game, because it's about us sort of getting as much creative and financial equity in the product and content that we create as possible. And that goes to merchandising, it goes to publishing, it goes to all of these different revenue streams. And so I'm always trying to figure out, ways to separate rights in a world where this issue, the studios have become really intransigent about all of it.
Yeah.
Exactly. Look, sorry, go ahead, Allison.
Well, they're just not going to give it to you. And I think what this is about in this panel is learning what you have a right to ask for, or what is actually already guaranteed to you in the MBA that nobody's going to tell you. Like, I didn't understand on an early project why I should have gone for screen story. And I didn't, because I was getting so much pressure to just accept the credits as they were. And now that has gone on to, movies and musicals, and I don't get any of that. So, but I didn't know, I didn't understand. And so I think a lot of it is knowing what you have a right to and knowing.
Allison, let me ask you a question.
Yes.
Brad, sorry to take over. This is a key issue that everyone needs to understand, meaning this project, we'll call it Project X, okay? All right. Were you getting pressure from your agents to accept sort of the credit that they were pushing on you? Explain that to me.
Studio and the director were pressuring me.
The producer and the director.
And the studio. Yeah.
And the studio, okay.
Mhm.
And what were your agents and what was your lawyer doing in the midst of that?
So my agents were fine for me to fight. Well, this is a complicated. Those agents I am no longer with. It was an automatic arbitration because of how things were. But
Can I ask you one other question as we go? Was the director also arbitrating to get credit on the movie?
Yes. And mainly what I didn't, and I was young and I didn't really understand what was going on, and it was heartbreaking. And but I didn't understand screen story. I didn't understand that was the thing I could ask for. I didn't understand that was the thing I could arbitrate for, and I should have. And the guild wasn't super forefront in explaining that to me or encouraging, honestly, to go for that, because it is a hard thing to get screen story.
What about your attorney?
My attorney didn't understand the situation. I don't think he, I did not know, let me just be honest with you. I did not know that screen story meant you might be able to get separated rights until Brad sent us the outline for this panel.
Yeah.
Okay.
So let me, go ahead, Eric, and then let me just explain for everybody who doesn't know just the basics of of separated rights here and really kind of what it is and what we're talking about.
Yes.
I'm going to press pause though for 1 second, because this is a perfect illustration of one thing that I think is a really good thing to bring up going into this, which is that nobody is going to fucking look out for you guys. No one. You have to educate yourself. You have to educate your lawyer and your agents. It is incumbent upon you to sort of know how to game it.
Agreed.
Because no one's going to do it for you, and it's easy for everyone just to, let you make a mistake, and so I think that's one of the big headline things of this panel, is that know your rights, know them inside and out, utilize the resources you have at the WGA to educate yourself. You know what I mean? And then, make sure your attorney especially is dialed into that frequency, because it's your attorney in most cases, not your agent, that's going to be your biggest advocate on this front. Brad.
Totally. No, makes a lot of sense. And I think to back up just a little in terms of, what separated rights really are, so people can, educate themselves. And that's what this is all about. And that's what we as the guild want to do. And, especially guild attorneys, because the more people who know about this, the better off writers are. So obviously, most people know that when you write something for employment in the United States, it's considered a work for hire, right, under the Copyright Act. And the company is the one who has all the ownership interest. They're the ones who have the ability to, make the decision as to whether or not they're actually going to produce the film. They're the ones with the creative control. And that's how copyright tends to work in the United States. Similarly, if you're selling something over to somebody, they're going to ask for everything. And they want all of the rights that are potentially part of this. So separated rights were actually was actually designed in, and theatrical separated rights specifically first came out of the 1960 MBA. So this was something that writers at the time, back in the 1950s and 60s, were dealing with, where they, didn't have certain additional rights and they wanted them, and theatrical writers were part of it, and were a big part of it, because at the time they couldn't sever the copyright. So what the MBA actually does is, if you think of the copyright as a bundle of rights, separated rights are things that the Guild MBA through collective bargaining peels off and reserves to the writer. So they're technically things that are licensed back, royalty free in perpetuity. And specific to, and you may see something in your contract that says, they acquire all right and this is a work for hire. Well, it's all subject to the Guild collective bargaining agreement, so it's subject to this. And for theatrical for theatrical films, these rights are publication rights, dramatic stage rights. There are certain creative rights, such as the ability to get a rewrite on original films, and then also the right to reacquisition, as well as payments for sequels. So these are all some of the rights that are things that are included. And in a second, we can talk about like how one actually qualifies for separated rights under the MBA and what that is. But I think, as you all were saying, we're talking about, these are really important rights. And I don't know, maybe you all had experience trying to reserve any rights with the studio when you're trying to sell over a project. And I don't know how that's particularly gone.
It never goes well. It's a wall of shitness. And so really right now, the only way, and I was going to ask you about this, Brad, but the only way I see any ability for us to separate rights is, as opposed to going out and selling a pitch or a screenplay directly to the studio, that you publish it first. Whether you do the comic book version of it, you do the graphic novel version of it, but by publishing essentially the screenplay first, it allows you to immediately separate the rights, and then maybe you can sell the gaming rights to a guy that who owns a gaming company, and then you go back to the studio with all of these rights that you've separated prior to going to sell the product to the studio, saying you can buy the film, you can buy the TV, you can buy, the lion's share of the merchandising, but I'm reserving and have carved out these things prior to me selling it to you.
Yeah, and I think that that's a good point with respect to what the qualifications are for separated rights under the MBA, because the MBA separated rights under the MBA apply to original material, and they vest in the story specifically. So you need to have an original literary material that's sold under the Guild jurisdiction, that's sold under the Guild jurisdiction or as a work for hire, that hasn't been previously exploited in another manner. Now, what you're talking about, Eric, is one of the ways that writers have historically done some of those things. But under the Guild MBA, if you've already, for example, exploited the publication rights and it's based on a novel, you won't be entitled to separation of rights in the Guild MBA. However, the reason that was done in the first place was because it was assumed that the writer who actually published a comic book or some, whatever it is, already would have the ability to reserve those rights, because at that point they had already sold those rights. So therefore it wasn't something that they necessarily needed to do in order to in order to qualify. So that, I think, is part of it. So it's really important that separated rights, the initial qualification is that you write an original story or original story and screenplay under the Guild jurisdiction in order to meet that kind of initial qualification test. So if it is based on a piece of pre-existing material previously exploited, so whether that's a video game or a book or a stage play, those are all things that potentially, if you get a based on credit, would initially be more difficult. Now, there's exceptions to that rule, and we can talk about the exceptions, and this gets into a little bit of something we mentioned earlier, but the exceptions are, one, the company doesn't actually give you that literary material, which happens more often than you might think, where they're like, say it's based on a book, and they're not even a book, when they say it's like based on an article about something, and then you're like, I've never seen this article, I don't know what you're talking about. Or the other thing is that if you with the knowledge and consent to the prior or subsequent from the company, substantially depart from the assigned story, that you created something new and different, then you can still be entitled to separation of rights. And that is actually the the test for copyright infringement effectively. And that's kind of where that comes from, to say that even in the event, and this is what we're talking a little more with screen story, and that gets to the final qualification, but even the event that they did something and it was based on a previously exploited piece of literary material, you can actually, if you substantially depart from what was previously given to you, you can actually still, if you get a qualifying credit, be qualified for separation of rights.
Let me ask you a question. If you sold a pitch to a studio that was inspired by Romeo and Juliet, okay, but it was your contemporary version of Romeo and Juliet, right? And it was just, the Hatfields versus the McCoys and the love story in at the center of it. But you wanted to call it Romeo and Juliet, right? But it was largely an original screenplay. Would that still meet the standard for being able to separate your rights?
So it does depend on, and we'll get to, and I'll just basically say, I should say now, I guess, that the final qualification for all this is that you get a qualifying credit. Qualifying credits are story credit, a screen story credit, or a written by credit, effectively, which is just a story and a screenplay combined, to do this. But to move back to what you're saying here, Eric, and I answer your question, I think really in that scenario, one, it would probably be a situation of, did you substantially depart from the underlying literary material such that it doesn't, it can have some similar elements to it, but if it's not, if you created a new and different and distinct story, then you may qualify under one of the exceptions, even though it is based on something, which is why it is, I will say it's more likely that you'd be able to qualify if something is inspired by a previous story than if it's based on and you follow that story through whatever that, the play or the book or whatever it is.
What about in terms of a reacquisition?
So that's slightly different, and we'll get into that in a second. But in a reacquisition, it really can't be based on any previously exploited piece of material. So the exceptions, which may necessarily apply for publication rights and dramatic stage rights as things move forward, are, for reacquisition, because it's happens early in the process and before credits are finalized, it's under the standard effectively is it's not based on any previously existing piece of literary material.
If you get story by or you get written by, you have separated rights for sure. But if you get screen story by, that you don't necessarily get separated rights, right?
So you don't necessarily have it for sure. It's a good question, Allison, because I think that that's kind of like the way that you would look at it. And I think that one of the things that comes up where people do see written by credits or story by credits in things where people cannot have separated rights is if there's been a previously exploited character that was the principal character. So studio gives you Spider-Man and they want to make a Spider-Man film, even though you create an entirely new and original story, and you may end up with a story credit or written by credit for that, because you utilize the previously existed character as a principal character in the film, you likely wouldn't qualify. There's an exception to that too. And the exception to that is in the event that you utilize a minor character from a previously existing piece of literary material, and that minor character subsequently wasn't really described in the previous piece of material. So you took somebody who might have been only in 1 or 2 scenes of a book or a previous movie or something, and then you created their whole story and the rest of it's original to you. It's possible that you'd be able to be entitled to one of those exceptions. And just one more thing to say under this is that whenever you get a qualifying credit for separated rights from the Guild, you'll get a letter. You'll get a form letter that comes from me, actually, that says you received a qualifying credit. If you get something that we think is original and all signs points to original, you'll basically get a letter that says you're qualified unless one of these things, and these are the things we're talking about. And it happens most often in Screen Story, but can happen otherwise, you get a letter that says, please contact us. The Guild actually has an obligation in situations where you qualify under one of those exceptions to inform the studio within 90 days of the credit that we believe you qualify. And that brings to whole fun back and forth.
And what if it's based on real people and real events?
So it can be based on real people and real events, and you can still qualify for separated rights. So just because it is somebody's life doesn't necessarily mean that's the case. And I'll say that the arbitration we tend to look at in that is, for example, a situation where a company gave somebody like court transcripts and said, we want you to talk about this court case and everything that went through it. And they put together, they said they assigned thousands of pages of court documents. Well, the writer had to go through, come up with the beginning, the middle, the end, figure out how to tell the story, figure out who they're going to focus on, what the characters are, what the point of view is, all of those things. And in that situation, the arbitrator determined that that writer was entitled to separation of rights, even though it was based on that because the writer made all of those individual choices.
Or let's say it's based on a book that wasn't actually written when you were writing the screenplay.
So that also is interesting because that also will depend on whether or not, was that book exploited? If that book wasn't completed and wasn't fully written yet, you may have a situation where some of that book comes up with elements that you put in the screenplay. If that book's written by the same people who are the company that otherwise, and it's possible in that scenario that those publication rights, to the extent that you have separated rights, may be yours in the event that your screenplay is not based on the book, but rather vice versa.
And that is why knowledge is power. Mm-hmm. All right. You want to talk about reacquisition?
Yeah. So let's go. Those are, and that's all, good to know in terms of like, that's the qualification and that's how it happens. And we talked about the things that are really there, and it's publication rights, it's dramatic stage rights, it's payments for sequel, and it's reacquisition, which is kind of one of the big things that writers care about. And I'll say that the separated rights provisions theatrically go back to 1960. The reacquisition procedures are a little bit newer than that. And in fact, they were really most robust and born out of the 1988 strike. So writers actually struck for this stuff to happen because studios were saying, you're never getting your scripts back. And they would do things like try to, tell people that it was stuck in active development, which we can get into a little bit to try to stop people from doing that. But reacquisition, so basically what it is if you have an original unproduced screenplay, the company has 5 years from which to exploit that literary material under the MBA. After the next 5 years after that, you as a writer have an opportunity to reacquire that material. If you said that happens by you contacting the Guild, and you both have done it, you know how this works. You contact the Guild will send a letter over to the company and tell the company, hey, so-and-so writer wants to acquire the screenplay. Once that letter goes out, you've given notice, and there is a 2-year window in which the writer can actually reacquire. What happens once we send that letter is the company responds really in one of 3 ways. They respond by saying, it's in active development, which is not always what happens, but we can talk. Eric, I know you want to talk about that one, but we could talk about it a little bit. Responds in the fact where they could place it into what we call effectively super active development, which means they're hiring a director another writer to do a rewrite, or a major actor on a pay or play basis to actually do work on the film. And that's something where they're spending real money. That's also not as common. By far the most common thing that they do is they provide us with the terms and conditions to reacquire the literary material. And those terms and conditions are, and I'll go through the technical, and then we can talk through some of the more real life situations on this. Those terms and conditions do say, like, you know, this is the purchase price. The purchase price, and all they're permitted to charge is what you got paid for the script. And they can't charge interest on that. And, you know, anything else, for example, that they have that's owed on it, like if they paid another writer to do a rewrite, if they, for the pension and health contributions for you or another writer, are considered what are other costs that are directly related to the literary material. Those they can charge interest on, but those aren't owed until the film actually gets made. Those aren't owed until the commencement of principal photography. So,
and it has to be a reasonable interest rate. They can't like be like, our interest rate is 272%. Like it has to be.
Arbitral precedent dictates it can be essentially no more than 125% of the current prime rate.
The other thing is that the interest rate is negotiable. And so in many cases, you can go back to the studio, you know, because sometimes in my case, you know, this is a lot of years running. So, you know, we've racked up, I'm sure, a decent amount of money. You know, most of the time the studios will work with you to negotiate that number down, because it's all found money for them.
And I'll say too, on that part of it, again, interest can't be charged on the original purchase price for you to buy it back. You get 6 months originally to tender that purchase price, which is what they paid you or what they bought the script for. After that, that would be yours. It's subject to the lien with the other direct costs for, you know, whatever that is, but those are only owed, as Eric said, like they're only owed when the movie gets made. So that becomes found money for the studio in the event that that movie gets made. And it is a lot better in terms of what costs end up being than traditional turnaround, because in that the studios can kind of charge whatever they want. The MBA specifically says they can't charge overhead, they can't charge costs of any other kind. So, and they can't do things like they normally do in turnaround, like say, we want to, you know, credit on this, we want, you know, percentage on the back end, we want whatever else if you're going to actually go and make this. So it is something that is, you know, usually better than the terms that you're going to get on that, you know, from the studio, if you were just to go yourself, not through the guild process. So with that, I mean, I guess both of you, just to talk about, I know you've both availed yourself at times to this, but yeah, I don't know, maybe you want to just talk to about, like, other than what I just laid out, like what your experience was with going through the process and asking for it, and also, like, you know, why you decided to do this on your particular projects. I don't know, Allison, you want to go first?
I go first. Do you remind me, is it 5 years after you last worked on it, or after anyone last worked on it?
After you last worked on it, if you're the original.
So yeah, so my agents are lovely people, and my managers lovely people, and they didn't know these rules, and they were blown away when I called them up. And I pretty much just did this, but I have a cough drop in my mouth, so hold on. Now I no longer have a cough drop. So I sold, God, I'm such a lady. So I sold a spec script, an original spec script called Agatha, about Agatha Christie. Was like missing in real life. She went missing for 11 days, and I wrote this fictional story about it. And we have been trying to get it back from Paramount. Like, the producers had done like lunch with the president, like they'd sent it to actresses that wanted to do it, and like nobody was budging. Paramount was not giving this script back. And then I did a panel, and Brad was like, said all this stuff. And I called him the next day and I was like, what the F? I want my script back.
You can say fuck, Allison.
I can say, I've been working for the mouse too much. So I was like, what the fuck, get it back for me. But I was panicked. Remember that, over the 2-year sliding scale? And I was like, I think it expires tomorrow. And you were like, it really doesn't. But if you're that terrified, like, I'll just send the letter. And I was like, okay, just send the letter. So we sent the letter, and within 60 days they responded, and they were like, yeah, here's your movie back. And I called my producers that are now in another studio, and they were going to buy it. And so that was the plan. The plan was to reacquire it and they would buy it. And then while we were making, so I got the rights back, and or the option to get the rights back. And as we were negotiating the deal, another one of their projects that got greenlit that was way too similar. They also didn't like my current quote, which whatever. So it fell apart, and then it was like Christmas, and then it was Omicron, and I didn't end up selling it. So I didn't sell it. And so now the 6-month window expired. However, now there's a foreign company that wants to make it, hopefully, but they're doing all their due diligence before they're going to put it in offer. So now I'm just sitting pretty because I'm in my 2-year window, right? So I'm waiting to see if this company will actually say, yes, we want to make this and we'll buy it. At which point I then call Brad again, and you send another letter to Paramount. And we hope that they don't put it into what is called super active development, I believe.
Yes.
Which means they have to like actually spend money on this. And then the company gets it and I get my movie back. And if they do put it into super active development, well, then I don't know, maybe Paramount will actually make it, which would also be good. But I actually, like I say this was, I got it back. Like it was just a letter. And then like 45 days later, they were like, here's your script. Like it just worked. I don't think Eric, you had such a pleasant experience.
No.
Sorry about that.
I am happy that you got your script back, and I'm hopeful and sending good vibes.
Thank you.
My experience was not as pleasant and or easy as yours.
Yes.
This, during the course of a career, I've written a lot of scripts, but this one, God bless the damn, was, maybe there's 2 or 3 scripts during the course of career that just, you love them. They're like old buddies. They're just, you love them. This one is one of those for me. So I got it back years ago. It was originally going to be made with Ron Howard at Universal. And we had an amazing cast, and we were in prep, and it all fell apart at the last minute. And so years ago, I got it back on the reversion from Universal with the help of the WGA. And I had, then you have, 6 months to go run for your money, essentially, to find another studio or individual to sort of pay the cost, stop the clock, and go with them. The individual that I ended up selling the script to was a very wealthy guy who decided he wanted to start a film company, and had said we were making the movie, made all kinds of promises, and didn't keep any of them, which was a drag, but okay, it happens. And so once again, after that 5-year period was over, I went to the WGA and said, all right, let's go get it back. But with this individual, it was not that easy. And essentially, Brad, you can correct me, but in essence, what this individual did in order to prevent me from reacquiring the script was, to me, he perpetrated a fraud. He abused sort of the rules. He gamed the system in a way that prevented me initially from reacquiring it. So once again, and that was then another 5 years later, I went back to the WGA, and this time Brad was there and Julia was there, and we looked at the case and realized that 1, the company was full of shit, but 2, that the case hinged on what defines active development. Because that's what they were claiming, was that, you know, the script was an active development. What they defined active development as was like, we're sending out emails to agents about the script. And that doesn't meet the threshold. That's bullshit. And so, you know, we went to battle with them. You know, the irony is, Brad, correct me if I'm wrong, this guy hired like the all-star team of legal teams and ended up spending, I would venture to say, a lot more money trying to hold on to the fucking script than I'm going to end up paying him, you know, because I got to believe he pulled down with that team. It must have been close to $1 million, maybe $1.5 million in legal costs.
I don't know what it was, but you know, it certainly wasn't cheap. And I will say that you had the benefit of the wonderful people at the WGA to help.
I got to tell you, man, it was the greatest thing ever, because either way we won, which was he was spending a fuck ton of money. And I know that he was going crazy. And we would just have these amazing, you know, going to arbitration, guys, it's kind of like going to court. In our case, we went to court. There was a judge presiding over the proceedings. You were cross-examined by his attorney. I mean, he was like, I felt like I was, you know, it was going to court. Anyway, so, but the essence of this case kind of hinged on what is it that defines active development? And for years, I feel like the Guild, that definition has been pretty foggy, which has allowed studios, producers to hold on to our scripts under the, using these sort of bullshit definitions. And so the real virtue of the case and that the WGA and the attorneys at the WGA fought for was, I think we all knew that if we won the case, it would set a precedent and that it would give us this definition and this clarity that we've been looking for a long time, and we would never have gotten it from the studios. We kind of backdoored our way into it.
Yeah, and that's all. Thanks, Eric. I mean, that's all really good, and that's absolutely correct, because when it comes to, like I said, the reacquisition process generally came out of, you know, a strike. And writers had to threaten a strike once with the initial process that came in earlier in the 80s, and then went on strike in 1988. And one of the big principal things was this. Now, absolutely, with respect to active development, the Guild has always taken the position or believed you have to spend real money. There are examples of what active development are in the MBA in an earlier provision that was subsequently rewritten in 1988 during the strike. But realistically, it was things like I said, hiring a writer to rewrite it, which, as you know, the writer has to be actively writing it. You can't hire one writer for a rewrite for 4 years and claim that writer is still writing the script. They need to be actively spending money on it. You need to be, you can hire a director, you can hire a major actor on a pay or play basis on it. That original definition of active development also includes if you're doing like a unit production manager who's engaged to furnish the budget or things like that. Those are things that they can utilize. But there wasn't a clean definition of this. And that's the thing, is it just lists examples. And the real problem was the studios were just trying to take the position that, like you said, I'm having lunch with directors' agents to see, and I tell them about 15 different things that we have going on at the same time.
And I think the virtue of this particular case is now we have some real definition, which is, in the broadest sense, they have to be spending fucking money. Not bullshit money either, real money, you know? And unless a studio, you know, or a company is spending real money, it is not active development. And, look, this fucking guy was a total prick and just, he's one of the bad guys and we won and that feels great. But I think the bigger thing that I'm really happy about is that, we get to, we got a new weapon in the battle, we get to use it and everyone should use it. And everyone should take advantage of it because, your scripts are just waiting, just sitting there on a shelf waiting for you to reacquire them. And once you do, you could find a new buyer and you can make money and you can get it made and you can define the terms. So it's all wide open. And I just, I'm just happy we won.
And I think one of the tricks that I will say is timing.
Yes.
It's very key on when you're going to ask, because one of the reasons I said send the letter was there was a regime change at Paramount and there was a new president that had only been in for like days. And I was like, now, because getting the green light to invest in a new writer or director in the next 60 days is going to be very, very hard. So let's go now. And I do think that helped us.
I think the other thing is that the more you know about sort of the lever and mechanisms of reacquiring the script, the more educated you are, the better result you're going to get. Because, ultimately, I can't tell you how many people called me and were just like, my lawyer said we couldn't do it.
Right.
And here's the dirty little truth that no one likes to talk about, which is a lot of the time your agents and your lawyers are not going to, let's say, they're not going to discourage you, but they're not going to encourage you. It's easier for them not to participate in reacquiring scripts because studios don't like it. They just don't. And so this idea of turnaround and getting a script put in a turnaround is kind of a joke because it's an empty gesture. Studios tack on so much fucking money to those turnaround costs. They make it cost prohibitive. And that's the point, which is on the one hand, they're like, Eric, we love you. And for you, we'll put it into turnaround, and then they tack on like $5 million.
Right. Because they have to
Bullshit
rent all that
cost.
studio lot space.
Eric, what do you, look, we have all this, money into it. We tried, we love you, knowing that you're never going to be able to get the money up to buy that script back. And no one's going to buy it because it's cost prohibitive. And that's the intention. They don't want you to get your script back.
Yeah. And also
The reason why is because, God forbid, you find a new buyer and the movie's a massive monster success. All of these studios that are holding your scripts, they look like assholes and they know it. And they don't want that to happen ever. And, that's just the bottom line. That's the truth of it.
Yeah, and I'll say that that's one of the great things about the reacquisition process too, is there are defined terms which say you can include this and you can include that. And that has been, litigated, or through the arbitration process, through the guild over and over again over the years of what can you include, what can you not include. And like, you're both saying, they're going to say, I'm going to include whatever I'm going to include to make sure that this never happens. Or if it does, it's just such a windfall to me that I don't care. So, I think, that's a big part of it too. So I wanted to touch on just one more thing about the reacquisition process in terms of this too, that comes up a lot. And this was actually the most recent negotiated provision, is you can also get a rewrite and reacquire a rewrite that is done while your script is under option. So if you have a spec script that you option to a studio and then they say, hey, we want to pay you to rewrite it, a lot of times what happens is they own that rewrite and they then make it more difficult for you to get it back, to be able to go back and set it up somewhere else. So the one that came in, I think it was 2014 or 2017, that we added this provision that says, after the 1 year after the expiration of the option, you get 5 years in which you can go through this process and reacquire the rewrite for the same thing. So if they pay you, guild minimum for a rewrite, or they pay you, $60,000 for a rewrite or whatever, even if it's more, you can get that rewrite back, so you can get a clean chain of title, and you can then go out, utilize the work that you did, and re-option or resell it to somebody else.
Which is critical. You got to have that clean chain of title.
Yeah, and I'm looking at the Q&A, and I just clarified. So I don't technically have Agatha back because I didn't pay the fee, right? So I had the option of paying back what I was paid to write it, which was not a lot of money, like barely more than, a little bit more than guild minimum, under 50. So I thought about investing and buying it back. And I was like, no, I don't want to do that. And I thought this company was going to buy it back for that. And they ended up pulling out of the deal and not doing it. So I don't have my script back. But if this foreign company says that they want it, I will trigger another letter, because I'm still in my 2-year window. They will have 60 days to respond. We will hope that they don't put it into super development, and the same terms will come back to me, except possibly at a higher interest rate, since interest rates are higher now, but I don't know if that'll be true. Did I go finance on you? But so at that point, the foreign investor will pay that fee to Paramount. Like, it's not my money that I'm using. So they will pay that money. And then if they make the movie and it goes into production, there was a writer that came after me that did like a rewrite. They owe her fee and her pension and health and interest, but that was also not a lot of money. So they can get my Agatha Christie script back for so much, like that 5 million turnaround they would have demanded, and an actual turnaround. I can get my Agatha Christie script back for not a lot of money.
But here's the other virtue, Allison, which is you can completely renegotiate that deal.
Yes.
The script technically, in a way, is yours.
Yes. And I plan to, which is also why that other, because the other company was like, we'll give you guild minimum to do a rewrite.
Right. Like, just because you sold it to Paramount for $10,
right,
doesn't mean now you can't renegotiate to sell it to the new buyer for $100.
Correct. Which was my plan, which is, or what I may do, because it's a foreign company, is I'm gonna be a producer and I'm gonna ask for
take a little equity, get a little piece.
I'm gonna take equity.
Right. And
but
so
you have the power. Yeah.
And there's a couple points there, things that you mentioned, Allison, that I think are really important too. Is one, so technically, until you pay that initial purchase price back, like, you don't have transfer, the title hasn't transferred, right? But once you pay that initial purchase price, you technically would have bought it back. It's subject to the lien, so you're talking about the cost of the other writer and the pension and health, but none of that is owed until somebody decides to make it. And the other thing too that mentioned on this is that, technically the way that the title transfers under the MBA is company A to writer to company B, but in reality, what we usually see happens is you go out, you get a buyer, you have somebody lined up, company B comes in and says, we're going to pay this on behalf of Allison.
Right. And now, because I'm going foreign and it's going to be much more of an indie, right? Because I think the original film was probably like a 60 to 80 million, and now it's more like can we do it for 20? I'm not going to be able to get a huge purchase price for that, but I could come on as a producer, right? Yeah. So
I think the other interesting thing is that there are going to be times where they're not just going to give it up, they're going to fight, and you're going to go to arbitration. In my case, there were multiple times where the company in question wanted to settle with me. They wanted to sort of end the arbitration and settle the case out. Meaning they're like, okay, Eric, we get it. You want the script back. We don't want to spend any more money in court. So let's work out a deal between us and end the arbitration. And the WGA negotiates or tries to negotiate the settlement on your behalf. In my particular case, there were multiple times where we could have settled, but they were, and that's a really viable option. The only reason why I chose not to do it was because if we settled, we wouldn't have the precedent. And so if I ended up settling with these guys, you know, we wouldn't have had the precedent that now we can use and everyone can use to go get their shit back. And because I hated the guy and I just wanted to win. But I think that, you know, it's an arduous, difficult, really time-intensive process for you, for the lawyers at WGA. And so you need to be up for that. And you need to be patient, because how many years was this we fought, Brad?
Well, if you're going just from the time that this came about again, that was what, April of 2020. So it was at least 2 years, 2.5.
Yeah, 2.5 years. So, and I'd been fighting a lot longer prior to that. So it was like a 7-year battle for me personally to get it back.
And I'm the asshole that was 45 days. So
Well, we're good.
this is Eric hopefully fought for a lot of you guys, right? Because you've got a precedence now, right?
Yeah,
All of us.
yeah, for
Just you.
everyone.
So I will say for all of us, thank you. Because it's a
And
big
I will
Hey,
say,
thank Brad and thank
Thank
Yeah.
all the guys at WGA and Julia and everyone. They killed it, and it really was one of the moments where I was like, fuck, I love my union. You know, I gripe about the union all the time, you know, not all the time, but I gripe. But we've had a really good run over these past few years, you know, and you know, we're making some really big strides. So
and I'll just
solidarity,
say-
baby.
yeah, thank you, Eric. I appreciate it. And I'll say, and then I think maybe we could turn to the Q&A after this. But I will say that it is far more common to have Allison's experience than it is Eric's experience. So don't let that completely deter you. But, you know, yeah, without it, you know, we do end up having these situations where companies try to do, and that was the whole reason why this provision had to be rewritten in 1988, because the companies were trying to, you know, pull this crap. And I'll say that we got the executive director from back in the 80s to come back and tell us what, you know, his understanding of this was, which was hugely helpful. So so that was really great.
Well, thank you all for being here. So much appreciation to express, and we have started a conversation or continued an ongoing conversation, and we want to hear from you. So please write to us if you still have any questions, and I'll let Allison and Eric and Brad have the last word.
Yeah, I'm just gonna say thank you everybody. I'll leave it to them to have the last word. They'll be much more eloquent than I am, but you know, I thank you everybody for this. Really, if you have any more questions or anything, reach out to contracts@wga.org. You'll get in touch with, you know, we'll eventually get in touch with me or one of our other great attorneys on staff who can help you out. And thank you, Eric, and thank you, Allison, for doing this. Really appreciate it.
Well, Brad, I gotta thank you. You know, you guys just killed it, and you were really there and really showed up. And I just, you know, I'm deep appreciation of my guild to you, all you guys. So
Yeah.
thank you.
I agree. I repeat that sentiment. I have called out many times when I think that I'm getting fucked, and I call contracts, and they have fought on a variety of levels for me. So I think if you have questions, we're so sometimes scared to reach out to the guild. Just do it. Just do it. Call, and you may be surprised that like there really are avenues that you can explore. And this reacquiring is a huge one. Huge. Yeah. I mean, the fact they have to reply in 60 days, that's bananas in this world.
Yeah.
So take advantage of it.
Yeah. Good luck, everyone. Go get your shit. And Allison, really good luck with Agatha.
Thank you. Thanks. I'm hoping
Yeah.
maybe someday you'll all see it and you'll be like, okay, that's what
I know
happened.
that girl.
I know that.
I did a webinar with her. All right.
That's right.
All right, guys. Good night. Thank you,
Thank
everyone.
you, everybody.
Thank you.
See ya.